My name is Stan Edelman. I'm visiting associate professor at the University of South Carolina School of Law. I will be talking today about a criminal procedure book, Cohen, Hall, and Edelman, 3rd edition, Criminal Procedure, the Post-Investigative Process, which means that this book is oriented to the criminal procedure course that's sometimes called bail to jail. It's from the beginning of the prosecution, the decision to charge, all the way through the criminal process, all the way through trial, appeal, and habeas corpus. It's comprehensive, designed to cover the entire gamut of the criminal adjudication process. The book is a comprehensive treatment of the entire adjudication process, beginning before the decision to prosecute, the initial appearance, arraignment, preliminary hearings, grand jury, discovery, pretrial process, trial, appeal, habeas corpus. It is a comprehensive presentation of the subject matter. The book is very practice-oriented, so that it's a mix of theory, certainly, and constitutional principles, but at all times the focus is on if one is the prosecutor, if one is the defendant, if one is a judge, what's one's role, what's one's strategy at any particular point along the criminal justice process. Our book expands coverage and is rather comprehensive in 3 ways. First would be in the area of plea bargaining, where we consider not only the mechanics of plea bargaining, but all the pros and cons, the different points of view of plea bargaining, whether sometimes might be called a necessary evil or whether it's a net good in the process. So discussion of the policy behind plea bargaining is very much in there, as well as very detailed and required, very necessary knowledge of the mechanics of plea bargaining. Secondly, sentencing is an area where there's been just an amazing amount of turnover, ferment in the law, new Supreme Court decisions coming down year by year. The book, especially in the updates, is up to date in the Supreme Court case law and doctrine with respect to sentencing. For those who are familiar with the Apprendi decision, casts a very, very great shadow in the area of sentencing. Third, lastly, the area of habeas corpus, post-conviction remedies, is something that I think many criminal procedure books touch on briefly, touch on lightly. It's an area with a lot of complexities. It's an area, again, that the book is comprehensive and up-to-date in its approach. And again, especially there is recent Supreme Court case law that has very dramatically affected the availability of the writ of habeas corpus, restricting it to a great degree, and the book is really quite up to date on that. The book is very adaptable to a number of areas where schools might wish to give small sections or seminars. One example comes to mind is the death penalty. The chapter on sentencing includes a major subsection on sentencing with pretty much all the relevant case law and history regarding the death penalty in the United States, that for seminar purposes, that could be the jumping off point. That could be maybe the first few weeks, the academic component of a seminar on the death penalty, from which students would then do their seminar papers and topics, but that would be sort of the foundation of knowledge that would apply there. And similarly, I could say for habeas corpus, and similarly, I could say for plea bargaining, the book would lend itself to small group consideration, and again, using those chapters or parts of the chapters as the jumping off point for more in-depth consideration. One section of the book that has been controversial from year to year is the section on double jeopardy. Students sometimes have a natural resistance to the idea that one criminal act can be prosecuted in Kentucky as well as Indiana, that multiple states can prosecute for the same act, that states or the federal government can prosecute. The concept is known as that of dual sovereignty. One criminal act is an affront to the peace and laws of more than one jurisdiction. Some students naturally reject that, and I've had some very spirited discussions about that particular topic, and some actually resistance to that topic. I am not only the co-author of this particular book, I am a satisfied user. I was teaching from this book for about 5 years. When the second edition was Cohen and Hall, I got in touch with Professor Emeritus Cohen, the lead author, uninvited, and had some positive suggestions to make. He got back to me and asked would I be willing to be co-author on the third edition, which was quite an honor. But I know the book from a teacher's perspective, presenting the book and covering the book and appreciating the book, and then from the perspective of having the opportunity to even shape the book further with my own thoughts and my own concepts. So that's been a very, very enjoyable process, approaching the book from both perspectives.